Hello, beautiful people. Mic check, mic check. Gemini the Queen says, ooh, wondered if you'd see this and cover this. Babe, I see everything. That hits a docket. I've got alerts set up for this man's name everywhere. So I was actually on the electronic filing website before this hit everybody else's notifications. I was just doing something else, or I would have been here sooner. And I was also planning on having a live later today. um, to talk about something else that has happened on a docket, which is actually where we're going to start because it'll be quick. But while the folks gather, we will get into another quick update that we have on the second docket, Nicole Key versus the world. Okay, with regard to everlasting base and like that. If you will recall, she and Rodney O sued the Barry White Trust, Metro Boomin, Future, Kendrick Lamar, the Barry White Trust attorneys, the record labels, John Doe's 1 through 10. I've told you several times about issues with serving the lawsuit, et cetera, et cetera, et cetera, et cetera. Since then, Rodney O has withdrawn from this lawsuit. He is not a party to this lawsuit. So it is solely Nicole Key alleging that she owns 50% of Everlasting Base, which we know from her own submissions is now under dispute with Rodney O. And I would imagine, yeah, with Rodney O. So we talked about this yesterday with an update. We've got a quick update before we go ahead and move into Aiden Ross officially entering the docket via multiple attorneys who have noticed the court that they will be appearing on his behalf in Megan Thee Stallion's lawsuit against Milagro Grams. He is not a party to the lawsuit. He is what is known as a third party. And he has received a subpoena and he is fighting it and claiming that he wasn't properly served, et cetera, et cetera. So we'll get into that document in just a quick moment. But prior to that, this morning, uh, this hit the docket. This is an order from Judge Cote in Nicole Key versus the Barry White Trust et al. As I just said, that includes Future, Metro Boomin, Kendrick Lamar, two attorneys representing the Barry White Trust, the record labels, and John Doe's 1 through 10. So this order comes down today from Judge Cote. An order of August 1, 2025, extended the deadline for service of the lawsuit, to August 29. It appearing that service may have been completed on all defendants except Leland Wayne, also known as Metro Boomin, it is hereby ordered that all defendants upon whom service has been completed shall respond to the complaint by October 6, 2025. It is further ordered that the plaintiff may file a submission by September 23, 2025, explaining why her claims against Metro Boomin, because it would appear that she has not served him, why they should not be dismissed with prejudice. If you don't serve the person, your case goes away. Dismissed with prejudice is very interesting because it means that she would not be able to file it again. So this is interestingly aggressive on the part of the court. This is my opinion. The dismissed with prejudice means it cannot be refiled. And so for the judge to say, explain to me by September 23rd why I should not dismiss this case against Metro Boomin heretofore is interesting. The other thing that the judge says in her order, which is interesting, is it appears that service may have been completed on all defendants. That is important. May. We've talked about this several times about whether or not service has actually been proper, because nobody else's attorneys have hit the docket. And you may or may not recall me sharing with you all that several receipts of service were entered onto the docket with photographs. There's a photograph of Kendrick Lamar's home. There's photographs of other places wherein the lawsuit has just been plastered. It's been taped. I assume the lawsuit has been taped. Okay, because when you serve somebody, you have the summons, is basically kind of your front cover. And then behind that, you have the complaint, which is the lawsuit that has been filed. So we can't see all of the pages, right? We just know at least one page or a stack of pages has been taped to people's properties. And that is not proper service. That's alternative service. And you have to have permission from the court for alternative service. And I don't know that I've necessarily seen her get permission for alternative service. And again, I've been waiting. There have been deadlines that have ticked past for people needing to respond to this lawsuit. The judge has since extended it to October 6th to say to anybody who has actually been properly served needs to respond to this lawsuit by October 6th. But one of the things that I found interesting about that, right? This is the paper order. That's what you're looking at here. This is going to be harder for you to see, but nevertheless, I'm going to put it on screen. This is the electronic filing website. So the same order has different language on the electronic filing website than it does on what we just looked at, the piece of paper. It says some of the same thing, but not necessarily the same thing. So I'll read it in full. It's going to start off sounding the same, but you'll see that it's not. An order of August 1, 2025 extended the deadline for service to August 29, it appearing that service may have been completed on all defendants except Leland Wayne, also known as Metro Boomin. It is hereby ordered that all defendants upon whom service has been completed shall respond to the complaint by October 6, 2025. It is further ordered that the plaintiff may file a submission by September 23 explaining why her claims against defendant Wayne should not be dismissed with prejudice. Barry White Family Trust, answer due 10-6. John Doe's 1 through 10, answer due 10-6. Kendrick Duckworth, answer due 10-6. Sony Music, answer due 10-6. Universal Music Group, answer due 10-6. Leland Wayne, answer due 10-6. Dorothy M. Weber, an attorney, answer due 10-6. Nevadius Wilburn, answer due 10-6. Signed by Judge Denise L. Cote yesterday, entered onto the docket today. So she is explicitly putting these people's names on the electronic filing website for any attorneys to see. If your client has actually been properly served this lawsuit, you need to respond. Now, are they going to get tagged in this or notified of this through the electronic? No, they're not. And they have not entered the docket to identify themselves and say they are representing any one of these parties. And again, I believe the reason for that is because service was not done properly, so they've just ignored it. You're not obligated to respond to something if you are not properly served. So there's that issue. So that is the very quick update on what is going on with Nicole Key versus the world over Everlasting Base and like that. How you doing, chat? Hit the like button. Good to see a nice, good group of folks here. A couple clarifying questions coming through. She's going around taping papers to people's doors. That's a great question. So based on what's on the docket, the receipts of services she filed were filled out by third parties. And those appear to be process servers or, couriers who were hired to deliver the paperwork. I've said this before, so for some people this is repetitive, but I'm going to say it again. when you hire a place that offers, these kinds of services, they don't tell you what to give them because arguably that could constitute legal advice, and they don't want to be liable for whether or not they did it to the legal standard required for your case, or whether or not they did it to their standard of fulfilling a service, of delivering what you gave them and told them to post somewhere. Okay? So you can pay them to do the wrong thing because you're the one dictating what they do. They're not really going to correct you in most cases because, again, depending on the place that's doing it, for their own liability, one could argue that that constitutes giving legal advice, and they're not qualified to do that, and they don't want to be liable for that. So if you give them a piece of paper and say, go serve this by any means, they're going to do that, and you're going to pay them for it. But that doesn't mean that they did it correctly. If you didn't give them the thing, and we know that she has served other people improperly. Dorothy Weber came onto the docket. Another attorney came onto the docket saying service is improper. So, and they've explained, they served us the summons, no lawsuit. And then they go to the rules of civil procedure and quote those in every instance. They served us this and not this and that. And that's not proper service. That's 089 level of what needs to be served. And she doesn't know that, even though she teaches ChatGPT. She doesn't know that because she's not a lawyer. So by September 23rd, she has to file her, here's why you should not dismiss this, which again is just an interesting thing from the judge. And I think it's an efficiency. I think it's an efficiency. The judge is saying, let's just talk about dismissal now under these terms. But what that is going to do is for anybody who has properly received this lawsuit through service or has waived service and accepted the lawsuit and agreed that they are going to respond to it, they are going to have insight into whatever her weak, lame legal arguments are for why the case should not be dismissed. So when they file their responses on October 6th, every single one of them is going to be a motion to dismiss. They're not just going to respond. Every single person who has been served this lawsuit is going to file a motion to dismiss. And they will have an upper hand because they will have seen her argument for why it should not. So that's the judge saying, point of order. What you got? She ain't got much. She ain't got much. But yeah, so I was going to share that with you all at 4:00. And then as I was off doing other things, I got a docket alert for a attorney noticing the court on the Megan Thee Stallion lawsuit. And I said, today? This is interesting. I wonder who it's for. And it was for Aiden Ross. And then another attorney for Aiden Ross came onto the docket, and their notices to the court explicitly say, we represent Aiden Ross, who is a non-party to this lawsuit. And we're prepared to receive motions from us on behalf of Aiden Ross. And so I said, okay, I'm gonna get ready to go live just to tell you that they're coming. And then by the time I had gotten here and able to go live, which wasn't very long, it was maybe 10 to 15 minutes, they had filed the motion to quash or protective order. So that is the document that we are about to look at now. Smash the like button. Shout out to everybody who's watching. It is great to have you here. Great to have you in the chat. If you feel like chatting or following along with the chat, make sure you change your chat settings from top chat to live chat so that you can catch all of the conversation. If you don't feel like chatting, you're just lurking, you're just watching. You can drop a, how you doing? You can say where you're watching from. I love to know that. Where in the world are you, beautiful viewer? Hit the like button, subscribe, Shout out to everybody who supports the channel and the work that we do here in the Docket Fund mods. Wink, wink, nudge, nudge. And the Docket Fund. This is how I am able to quickly, bring you things because I pay for them. I sure do. With the help of these lovely, lovely people who support the channel. So here we are. As I said, I believe just yesterday, I have alerts set everywhere in multiple states for Joe Budden, Aiden Ross, Livingston Allen, the people that have been squawking and saying, it's the Rock Nation Illuminati. Rock Nation ain't got shit to do with it. Okay, let's just get factual. That's what we do here. Factual. I don't care about your conspiracy. Okay, it doesn't matter here. We deal with facts on the docket, and Rock Nation isn't on the docket in this case. So I have alerts set everywhere, particularly since Livingston and Aiden started complaining about subpoenas and potentially being dragged into court for obstructing depositions, et cetera, et cetera. So I have been combing, looking, waiting, knowing somewhere something is going to come. I really kind of expected it to come on either in them going after Livingston Allen for obstruction of his deposition or her just suing all of them. I've said that for a couple weeks. I think she's going to sue all of these people together. But surprise, 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 surprise. It has come in the form of at least 2 attorneys on behalf of Aiden Ross. Non-party Aiden Ross's motion to quash or protective order. Freudian slip. Let me wet my whistle because we're about to get into a good old document read. Yes. Hello, beautiful. Good. I do my time. Let's talk about it after this. Remind me, okay? Non-party Aiden Ross, by and through undersigned counsel, respectfully moves this court, pursuant to federal rules of civil procedure, to quash or issue a protective order for a subpoena sought by plaintiff Megan Pete, and in support thereof states as follows. On August 28, plaintiff purported to serve a subpoena upon Mr. Ross, commanding both the production of documents and his personal appearance for deposition for September 16. Instead of knocking on the door or ringing the bell, plaintiff hired a mariachi band to play music outside his home to lure Ross and serve him. This, I just got to say as an aside, this next sentence cracks me up because fateless check me. It doesn't mean anything legally per se. It does, but it doesn't. This was too clever by half, or should we say, passare di listo. Personal service was not made. Mr. Ross has security who does not reside with him to shoo the band away. The security officer was not authorized to accept service. Pause. They don't have to be authorized to accept service. You have to be identifiable reasonably as somebody over the age of 18, of sound mind and body, on the premises, with access to its occupants. I just wanted to, okay. The mariachi band stunt trivialized the judicial process and was meant to harass and embarrass. Also, the subpoena seeks extensive documents and communications, including call logs, messages, payments, and social media posts to a person that has nothing to do with the facts of this case. This subpoena should be quashed or protective order issued for multiple reasons, including improper service, lack of relevance, undue burden, and harassment. Oh, they're going to get sued, boy. They're going to get sued. On the one hand, I give it to Aiden Ross for saying, fuck that, we're going on to the docket. I'm going to pay lawyers to fight this. That is a strategy. But what are you revealing in that strategy? We're about to find out. But we just found out a lot. But we're about to find out more. What are you revealing in that strategy? Is it worth it? The trial court is given wide discretion in setting the limits of discovery, and its judgment will be overturned only when a clear erroneous principle of law is applied or no evidence rationally supports the decision. Case law, case law, case law, case law. Under the good cause standard, the court must balance the competing interests of the parties and has broad discretion in determining whether a protective order is warranted. Rule 26 protects those from whom discovery is sought from annoyance, embarrassment, oppression, or undue burden or expense. Good cause exists to prevent plaintiff from taking the deposition. In turn, good cause exists to prevent plaintiff from taking the deposition. Period. Under Federal Rule 45, a subpoena must be personally delivered to a non-party. Substitute service of process is not permitted. Oh, okay. Party versus non-party. Let me check what I said, because I was thinking party when I said, I was subconsciously not realizing that I was referring to a scenario of party service when I said what I said about serving a complaint. But he's a non-party. He's a third party. And this is not a lawsuit. It's a subpoena for a deposition. So I've learned something. Okay. Under Federal Rule 45, a subpoena must be personally delivered to a non-party. Substitute service of process is not permitted. Well, I'm pretty sure that they're really cherry picking from those rules what sentences they use and don't use, because I know that's not true. The subpoena must be quashed due to improper service. Serving a subpoena requires delivering a copy to the named person, ... means they took out a bunch of stuff. However, as plaintiff points out, courts in this circuit have more recently blah, blah, blah. Because a non-party has nothing directly to do with the case, a higher standard of service is required. Non-party Aiden Ross was not lured or served by the mariachi band tasked with delivering the subpoena. Because he was not personally served, the service was insufficient and its effect must be quashed. The subpoena is overbroad and is a fishing expedition. Federal Rules of Civil Procedure requires the court to quash a subpoena that subjects a person to undue burden. Additionally, Rule 45 mandates quashing a subpoena that requires disclosure of privileged or other protected matter if no exception or waiver applies. Courts have consistently held that relevance is a prerequisite for non-party discovery, and the burden of demonstrating relevance rests with the party seeking discovery. Federal courts recognize that non-parties deserve heightened protection from discovery burdens because they have no stake in the litigation. Under Federal Rule of Civil Procedure 26, discovery is limited to matters that are relevant to any party's claim or defense. This relevance requirement applies with even greater force to non-party discovery. Courts have quashed subpoenas directed at non-parties when the requesting party cannot demonstrate how the non-party possesses relevant information. Well, babe, I don't actually think that's going to be difficult because your client doesn't know how to shut the fuck up. So there's that. The complaint in this action makes no mention of Mr. Ross whatsoever. A review of the pleadings reveals that the dispute between Ms. Pete and Ms. Cooper does not involve any facts, circumstances, or legal theories that would implicate Mr. Ross or suggest he possesses relevant information. The complete absence of any reference to Mr. Ross in the complaint is strong evidence that his deposition would not yield discoverable information. I disagree. The party seeking Mr. Ross's deposition bears the burden of demonstrating relevance. Okay, that fine. Again, not going to be difficult. Thanks to your conspiratorial groiper head ass client. The party seeking Mr. Ross's deposition bears a burden to demonstrate relevance. Federal rule limits discovery to information relevant to any party's claim or defense. Nothing in the operative complaint nor the subpoena itself offers any explanation what information Mr. Ross possesses relevant to the claims asserted by Plaintiff Pete, the defenses raised by Defendant Cooper, the damages sought in this litigation, any other matter germane to the case. Without such a showing, the subpoena constitutes an impermissible fishing expedition that courts routinely reject. The trial court, however, is given wide discretion in setting the limits of discovery. As a non-party to this litigation, Mr. Ross is entitled to enhanced protection from discovery burdens. Unlike parties who chose to engage in litigation, non-parties have not voluntarily subjected themselves to the discovery process. This court should apply a higher level of scrutiny to the non-party subpoena and require a stronger showing of relevance and necessity. The subpoena should be narrowly tailored and limited to information that is necessary and is reasonably calculated to lead to discoverable evidence in this. Here, the complete absence of any connection between Mr. Ross and the subject matter of the litigation demonstrates that his deposition would impose an undue burden without any corresponding benefit to the administration of justice. The court should grant the motion to quash or grant a protective order to non-party Aiden Ross. So again, another point of order. It's not true to say that there's nothing on the docket related to your client because last week Megan submitted a document that has over 400 pieces of identifiable evidence and your client's name is on more than one of them. I'm just maybe you missed that. The conversation that I would be having with my attorney today if I were Megan is what is the most efficient way legally to get information out of these people? They should be served a notice of intent to file a claim against them today and to preserve all documents and records in their possession. She should sue them. Oh my God. His motion has been terminated. Breaking news. Aiden Ross's motion has been terminated by the court. It has been struck by the court. Paperless order. When you heard, if I don't know if you heard that ding, that was a notification coming through. Literally, if you heard that ding, that was the notification. It literally just happened. Oh, sorry. I just realized you can't see the screen. So sorry. You can't. Again, I'll read it. Paperless order striking docket number 147. Oh, we have a declaration of Aiden. Hold on. I got to take this off screen for a second. There's 2 new documents. I have to take this off screen for just a second because I don't want to accidentally show my account information. Okay. Here's the first thing we're going to look at because this is what was just struck by the judge. So let me get my together, okay? There is a declaration in Aiden Ross's voice. Declaration of Aiden Ross in support of motion to quash. I, Aiden Ross, hereby declare under penalty of perjury. I reside within the jurisdiction of the Southern District of Florida. On or about August 28, 2025, I became aware that plaintiff sent a mariachi band to perform on my property, specifically in my front yard at my home in Davie, Florida. While the mariachi band was performing on my property, a security officer who does not reside with me and is not authorized to accept legal documents on my behalf went outside to request that the band leave the premises. At that time, an individual acting on plaintiff's behalf handed the subpoena for deposition and document production to the security officer rather than to me personally. I did not receive the subpoena directly, and my security officer is not otherwise authorized under any agreement or legal arrangement to accept service or legal process. Oh, yeah. So his his declaration has been struck and his motion to quash has been terminated. So here's what it says. Paperless order striking 147. That's what we just read, his declaration. Filed by Aiden Ross. Oh, so they're both struck and the motion is terminated. So struck off the docket, but it will always be there. Is his declaration and his motion to quash. The motion to quash is terminated. Parties are to comply with Judge Reed's discovery procedures found on the court's website entitled Standing Discovery Order for Magistrate Judge Lisette M. Reed. See also this docket number 62. Specifically, the party requesting relief must properly confer or attempt to confer with the opposing party, i.e., in person or over the phone, regarding the relief sought. If parties are unable to resolve the dispute, they must request a discovery hearing by contacting Judge Regis Chambers by email, in which they shall copy all opposing counsel, certify a proper conferral or an attempt, certify that a proper conferral or attempted conferral did occur, and provide all counsel's availability for a hearing. Please see the standing discovery order for more details. They didn't follow the court's rules in how you deal with these disputes. So he paid lawyers good money to do this for him. They didn't follow the court's established standing orders, which when they're standing orders, that means that they're added to the docket of every case, which means they're on this docket. It says this docket number 62. Let's see, let's go from 148 to 62 and see what's down there. And the federal rules, but you have to check the judge's individual rules. They all have websites. And if they have special individual rules for how shit gets done in their courtroom, you're going to find it there. And they didn't check that. So, grand opening, grand closing. Grand opening, grand closing. So the motion to quash has been quashed. I don't know if they told their client, hey, actually what we're supposed to do is try and deal with this behind closed doors or ask for a hearing. And he said, do it anyway. Or more likely, because I believe that most attorneys have professional integrity until they demonstrate that they really don't. More than likely, they didn't check. They probably didn't even realize that a magistrate judge was also on this case and not just the main judge over the trial for discovery related issues and shit for other procedural stuff. Like a helper judge. They probably didn't even realize that. Because when I was like, Judge Reed is not the one on the trial. No, Judge Reed is the magistrate judge on this case that handles shit like discovery issues. And I was just like, oh, yeah, right. So just that fast. Grand opening, grand closing. Literally just filed, already been struck by the court. And it's a no, dog. They said actually. Actually, all this shit is completely irrelevant. Let me tell you how we do things in my courtroom. Boy, this is irrelevant. A declaration, that's cute. That's cute. You got 2 lawyers coming onto the docket for you. That's nice and unnecessary. They don't need to be here either. Boy, tell your lawyers to email Meg's lawyers. Or if you can't work it out, then yes, we go for a discovery hearing to determine what your client does or does not have to give over. We go straight to the heart of the issue. Service is irrelevant at this point in time. So at the point that they knew that their client was trying to be served, they should have advised him, don't destroy anything. Just don't touch anything. Let us do what we do. Don't touch anything, because Meg is on them, and if she doesn't get it this way, she gonna sue these people. Oh, mariachi man. Aw. You're a big old whiny ass baby. Whiny boy. No, they're extremely arrogant and they think that money can, fix everything. So he used his money to tell his lawyers, go fight this in court, and they did it wrong. That's hilarious. I'm sorry, but that's low-key hilarious. Oh, God. I don't know. I don't know that white boy. They all seem to enjoy being obstructionists. So it's good. I mean, just like Rodney O getting a lawyer is a good thing. It's good that he has lawyers. He should shut the hell up publicly. Period. He doesn't need to talk about this, and it's a liability for him to talk about it because she's on his ass and she's going to get it one way or the other. If she doesn't get it this way, I still do firmly believe that she is going to sue a number of people together. So the first thing that was coming to my mind as I was reading the motion to quash was, when stuff like this comes up, it is not uncommon for a judge to just ask a lawyer straight up, will you receive the subpoena? And then debate with them about whether or not they are or not authorized to receive the subpoena based on the fact that they're arguing against the subpoena. And then they usually wind up accepting service of the subpoena. So the first order of business in a meet and confer between Meg's lawyers and Aiden Ross's lawyers are you going to accept service of this subpoena on behalf of your client? If they say no, what's your calendar say? We're going to the judge to argue what we want from him and to show relevance. We're cutting straight to there's not going to be no tit for tat on paper about was he served properly. The judge was like, that is irrelevant. This is about evidence in a case. You either work it out between y'all what you're going to share, or we go to an evidential hearing. And he can sit up there and say, I didn't know, but he talks enough big shit, boy. You either have shit or you're going to have to stand up in court and say, I was just talking big shit. Old school Gemini. Thank you, beautiful. I appreciate the support. So they're in a catch-22 situation here, because the first order of business with the judge says you're supposed to try and work it out amongst yourselves. And the first thing that they have to work out is not particularly what do you want, but are you accepting the subpoena on behalf of your client? How you going to talk to us about the subpoena or argue against it, but not accept it? The fuck? Well, we'll just pass all that and go and try and convince the judge that we do have relevance for things that we want from him, including a deposition under oath. And you can argue against us. That was a turn. That was a turn. Boy, oh boy, that was a turn. Wow, what a roller coaster we just went on. Because I was like, oh God, here we go. So begins the tit for tat, the back and forth. And oh my God, are we going to have to deal with that because now I'm sitting here like initially before the judge hit the docket, but initially just looking at Aiden's filings, I was thinking to myself, Livingston's next. He's going to have some lawyers file some, some bombastic shit that they can weaponize on their platforms, right? But anybody who just saw what just happened to Aiden is not going to employ the same tactics. This is serious. This is real world shit. Aiden Ross talking about, I was only going to do a deposition and, if I could live stream it. You are a fucking joke of a human being. And the exact problem with society. That's not only unreasonable, it's laughable and pathetic. That's not how the adult real world works. And nobody is going to allow you to do that. Certainly not a judge. So how does this actually get resolved? Not with performative bullshit. According to the judge, get on the phone, have a meeting in person, Zoom if you want to. I don't give a shit. Work it out or set a court hearing to plead your cases. Service aside. I'm dead. I'm dead. Said www.judgeread.com. You don't know where to look for my individual rules? Okay. I refer you to. Oh, jeez, man. Them some expensive lawyers too. Boy, what you doing? Oh God, that was I don't know if that was crafty or childish and stupid, ineffective, in terms of service. But it's crazy how I said at the very beginning before we got into his document, like, okay, so this is the strategy he's decided to, deploy. And but what do you give away in that strategy? Boy, he gave away everything. He gave away everything. The battleground, the argument, the everything. He gave away everything. Gone. You got nothing to work with. You got nothing to work with. Here I was thinking, well, he's going to be showing a bit of a hand. Nope. Oh, God. That's my favorites. Quite honestly, my favorites. Yeah. Yeah. I hoped, I was like, well, I'm going to let you know that it's coming because there's lawyers hitting the docket saying we are about to file this, that, and the other. So, and then it hit, and then you literally saw what happened after that. Oh, good God. Striking 147, striking 146. Your declaration under penalty of perjury, the judge crumpled it up and threw it away. Your motion to quash, Motion for a protective confidentiality order. Judge literally took a match to it, set it on fire like it never existed. We're going to have this conversation in the future because trust me when I say things are converging in the same place. But that's a loaded question. Judge threw it on the floor and told him to pick it up and get out. Said, pick up your garbage and get out. Oh my God, that was so delicious. That was fantastic. Wow. I don't even know what to say. I really don't. Like I said, grand opening, grand closing. No soup for you. Definitely no titties. Jesus, that's not even a question. Oh, I think I actually have the subpoena. This is hilarious. This is hilarious. They put the subpoena on the docket. I was not personally served. The only reason we have the subpoena is because you put it on the docket. I'm dead. I'm dead. I'm dead. I missed that the first time. Hold on. It don't take me but a second to watermark these things. Oh, I gotta download it. Oh God, Aiden Ross. Whoever decided the spelling of subpoena should face war crimes. The fuck is the matter with you? Anyway. Not that one. Nope. I missed this. They filed it with something. They filed it with something, and I missed it. But I have it now, so we might as well look at it, right? Right? I'm pretty sure they've already redacted it if their title is true and correct. We looked at one of these in Drake v. UMG. Deposition will be recorded by court reporter and videographer. Blah, 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 blah. Attachment A to the subpoena to testify at a deposition to Aiden Ross. You are hereby requested to produce for inspection and copying the documents and communications identified below. Call log. Sorry, they've got definitions. We've looked at this before. Unless otherwise defined, all phrases and words herein shall be accorded their usual meaning and shall be interpreted in their common ordinary sense. However, for purposes of this subpoena, the words set forth below shall be defined as follows. Call log, civil action, communication. WhatsApp, IMS, Slack, Facebook, Messenger, Google Messages, Microsoft Teams, Zoom, Cisco, WebEx, Signal Line, WeChat, Wicker, Snapchat, Telegram. Okay, criminal action, Daystar Peterson, defendant, documents, item of value, Miss Pete, payment, Peterson Group. The Peterson Group shall refer to the following individuals, both collectively and individually, and or any combination of persons. Oh, okay. Sunstar Peterson, Caesar McDowell, Mitch McDowell, Danielle Frost, Todd Perry II, Chennai Jackson, Walter Roberts, Gianno Caldwell, Diana London, Anna Paulina Luna. I'm fucking dead. Oh my God, she's going after that psycho broad in Florida. Woo! Oh, I just got like chills. Mari Ronquillo, any member of Daystar Peterson's counsel for the criminal trial or related appellate action, including but not limited to any member of Unite the People. They got a bunch of people named there. And any of their agents, representatives, associates, paralegals, or other affiliated personnel. They have a definition for social media post, you and your, and then of course in subpoenas come with instructions, and discovery requests come with instructions. So they've got instructions here. Documents requested. All documents and communications between you and defendant that refer or relate to Miss Pete, the civil action or the criminal action. Okay, now keep in mind that we just read 15 minutes ago a motion to quash that has been quashed. But we just read a motion to quash that said Megan failed to, in her subpoena, identify anything specific in relation to Aiden Ross and the defendant in this case. And the very first document requested is all documents and communications between you and defendant that refer to or relate to Miss Pete, the civil action or the criminal action. All documents and communications between you and Daystar Peterson or any member of the Peterson Group that refer to or relate to Miss Pete or defendant. All documents and communications that constitute, memorialize, refer, or relate to payments made, items of value exchanged between you and defendant. All documents and communications that constitute, memorialize, refer, or relate to any payments made or items of value given by Daystar Peterson or any member of the Peterson Group to defendant. All documents and communications that constitute, memorialize, refer, or relate to any interactions between defendant and Daystar Peterson or any member of the Peterson Group. All documents and communications that refer or relate to defendant's social media posts about Miss Pete, the civil action, or the criminal action. All call logs between you and defendant. She's the fucking worst. Just fucking trash. No integrity whatsoever. The biscuit headassery is insane. The Peterson Group is crazy. Okay, I think I know we technically started the LBG, and then we got this because I missed it. Again, my apologies. So we learned a lot through this frivolous and legally inappropriate attempt to quash the subpoena. Strategy fail, but we learned a lot. There is a Peterson Group, allegedly. They've all been identified. Interestingly, I don't recall seeing Livingston Allen on there. He's not. Which seems like a misstep, but I'm sure they can correct that. Yeah, I saw that as well. I addressed that the other day. That's not the point. The point is he's not mentioned as part of the group. I'm referring to the Peterson Group. I don't see his name there. That seems like an oversight or a mistake. According to him, he said, Rock Nation is trying to take me to court in New Jersey about my deposition. Rock Nation is not a party to this case, so they're not trying to do shit. He just needs the conspiracy because he's a right-wing nut job and his audience thrives on that. So I have not seen anything come up in New Jersey yet with Meg filing something trying to hold him in contempt for obstructing his deposition. I've been waiting for that. I had obviously no idea this was gonna come. Wasn't even anticipating that Aiden Ross might enter the docket. Um, I've been waiting for, is she gonna go after Livingston on the deposition issue? Or is she just gonna say, "I don't have time for this bullshit. Wrap them all up in one and sue them." And if they can't get what they if he did obstruct his deposition, and if Susan McDowell has allegedly obstructed his deposition, she has to file something on him in California to enforce, to get the court to enforce a new deposition. But if all of these people have just decided that they're gonna, decline, not participate, or obstruct the process, but she feels like they are intricately involved in what was done to her, allegedly, then she's just gonna sue them. Why would she let it go? That makes no sense. And why would she let it go in a perceived position of having lost something to where they now feel even more empowered? Fuck no. She didn't enter into all of this for that to be the fucking outcome. At some point, it becomes an all or nothing proposition. And also just inefficiency. Are you going to keep playing whack-a-mole? Or are you going to wrap them into one tortilla and then smash them with the frying pan? Joe Budden has definitely been a shit talker. Joe Budden has definitely said things that have not been proven, but I never got the sense that Joe Budden was actively behind the scenes trying to orchestrate. He's a lazy, couch coochie. He's opportunistic. And he says inflammatory shit. But I never got the sense that it's like these people who are in constant communication with each other, who are arrogant, who are behind the scenes, who are communicating with each other, they want to try and destroy this woman. And they'll never get caught. Head ass. They'll never figure it out. Motherfucker, people figured it out day one. Dummy. 1988 Jeffy. Their business model, being dumb as fuck and live streaming it, collides with their legal interests in court. They need a delay on their live streams. They really do. That's why when the Aiden Ross's attorneys are like, Megan has no reason to believe my client has anything to do with anything. Yes, she does. Because your client doesn't know how to shut the fuck up. How did we learn about the subpoena and the mariachi band? From your fucking client. Oh, my lawyer says this, my lawyer says that. Your client is breaking privilege in front of everybody, and you know it, and I'm sure it's making you panic. You need to tell him to shut the fuck up or that you will withdraw. These people are really pathetic people. Really, really pathetic people. So, yeah. Wow. Grand opening, grand closing. We're technically in the LBG, so what's going on? I hope the hell so. I hope the hell so. Yeah. So that's that. I'm like, what else do you, I don't know. I don't know. That's it. That's it. Mm-hmm. Mm-hmm. Both of these cases have had interesting docket developments today. I mean, Nicole Key being told by the judge, go ahead and show your hand on motion to dismiss up front. And then just literally naming everybody. If you have been properly served by this woman, this is when your response is due. Is crazy work, but necessary in this situation. Uh, I guess we'll find out by October 6th if anybody else's lawyers, hit the docket to file a motion to dismiss or to argue about whether or not service was proper or not. I don't know. But I'm still on her saying, why shouldn't this be dismissed against this one person forever? She gonna be in a pickle with that one. She should have just withdrawn the damn fucking case. But she's a layman's term egomaniac, so I don't know. It's up for a jury to decide those kinds of damages. I mean, you can suggest what you think is an amount. I always think the better strategy is to leave it up to a jury. Um, she does have damages that she can demonstrate. We learned that from looking at her list of over 400 pieces of evidence that she plans to have at the trial. It includes communications about deals that were lost because they thought that she was unstable in some kind of way because of this narrative that was put out about her. So it depends, but she would have to sue him. She can't get damages from him as a third party. She would have to sue him. So, yeah. It doesn't smell like prison to me. It doesn't smell like prison to me. You're not going to prison in a civil case, and these are civil cases. So, it smells like bankruptcy. That's what it smells like. It smells like being bankrupted. What an unfair stigma for mariachi music. Am I about to get served? That's crazy. Well, yeah, because then you cease to have any relevance because you don't have any resource to keep you out in front of people. That's the point after going after any of these people, is to make them pay an enormous sum of money that you can't put on a credit card. I'm so dead. Gemini the Queen says, I know it's civil, but what can be discovered could be criminal. Okay, sure. Uh, then it's up to the person to decide if they want to go that route. Law enforcement isn't keeping an eye on this case. They don't give a shit. There are plenty of civil cases where criminal activity is exposed and nothing happens. So, who knows? Mhm. I hear you. I hear you. I feel you. I appreciate it. It's called nuance, and I appreciate it. I think it's funny that that is probably gonna be a trigger for them. You know? It probably is. It's gonna be a reminder for them for a while of this situation, and that's just funny. That's just funny. We love nuance here, babe. Love it. So, yeah, we'll see. I'm glad this got really simplified really quickly because people acting like idiots on the docket is just really exhausting, you know? And it's unnecessary. We just talked about this yesterday where I'm like, I do not like dysfunction in situations where it's not necessary. And so anytime somebody just fucking slices through it, and it's just like, no, actually, here's what it is, and here's what you're gonna do. I'm just like, oh, because it's just vastly simplified the whole process that we're gonna observe and that we're gonna go through, and that's great. You know, that's great. Stop fucking pussyfooting around. Either work this out between the two of y'all, or come swing your best in court and argue that there's no relevance over here. What possibly could my client have to offer? Oh, gee, I don't know. I'm gonna be chuckling about this for the rest of the day, just so we're clear. I'm gonna be chuckling about this for the rest of the day. That while we were sitting here, that shit got struck off the docket by the judge. That is fucking hilarious. One time for the judge, just honorary. Actually, there's a couple of them that are relevant right now.
I study rap battles for a living.
Hired the best lawyers, obviously. Obviously. But bro,
just pull yourself together.
Judge said It's so much worse. I mean, he was immediately embarrassed. I know that he was thinking this is going to be content. This is going to be blah, 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 blah. It's going to be a narrative shifter. It's going to show that she's a client. It's going to da, 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 da. And that shit backfired. I, in ways nobody could predict it, because who was thinking about the judge's individual rules? Not us, apparently. Not Aiden Ross's lawyers either. Oh my God. Incredible. That is the backfire of all backfires. Yeah, it's apparent at this point in time. He was already held in contempt for his first deposition. I do believe, because he had to pay attorney's fees. I'm pretty sure that was for his first deposition. And he had to pay attorney's fees. Milagro had to pay attorney's fees on delayed production. Caesar McDowell is going through motion to compel right now. No, that one was struck off for jurisdiction. That's when the judge was like, you need to file this where the thing happened. Which is why Aiden in Florida tried to go straight to the docket to fight it. And the judge was like, actually, no, beloved, that's not what we're going to do here. Since you're here. No. Oh, God, that's so rich. Luna Lemon 11. This is also how I learned judges have individual rules. Yes, as long as they don't conflict with the federal rules or the local rules, judges are free to make their own individual rules. And they tend to do it around, they tend to create rules around efficiency or clarity. And a standing order, a rule that then becomes a standing order, like all parties heretofore in my court, regardless of the case, are subject to this order. It goes on every single docket because everybody is subject to it. It's a standing order, and it's on my website. Oh, God. Marshall Irons asks, what's the turnaround time for that? What's the turnaround time for what? What is that you are asking me about? If you just got here, you can run it back and watch the replay and watch us look at the subpoena where they describe why it is that they want to do that. Nobody here is going to explain it to you. I'm certainly not going to repeat myself. Does the docket have timestamps when the motion was put in and then when the motion was put down? No, the docket does not have timestamps on it, but I can give you a rough estimate. let's see. I think it's about an hour to 90 minutes. Because what time did this live start? Yeah, I started with you all at 10 after 2. It came in about 1:45. 1:45 is when I got the notice of the first attorney. By the time I sat down at my desk at 2:00, the motion to quash was on the docket. I started with you all at 2:10. And then at 3:08, we got the notice that it was struck off the docket. So I'm on the West Coast, so I'm going off of West Coast time zone. So I started here with you all at 2:10. It came on at about 2, and then the email notification for it being struck off. Actually, the order for it being struck off was actually at 2:40, and then I got a follow-up email at 3:08. It was repetitive. But now that I'm looking at my email, so it was on the docket for 40 minutes, roughly, before it got struck off. If I'm going by notification time. Sometimes, again, when I'm on the thing, I can see it before I actually get a notification for it. But this time I went off of notifications, so this is a fair estimate of it came on at about 2, and then the order striking is in an email alert to me at 2:40. .308 was the second notification, and it was a repetitive notification, but the first notification was at 2:40. After office hours. After office hours. B. Billy, too clever. Sorry, y'all, I'm far back, but that threw me. It's all right, beautiful. It's all right. I laughed at it when I first saw it when I downloaded the document. I was like, this is ridiculous. This is ridiculous. I was like, is this an actual legal thing? And it's not. It's something that lawyers it's a language, it's a term that they will use, but it's not, there's no like, it's not a legal thing. This was too clever. It's just a polite way of saying she was being slick. And we think it was unserious and unbecoming. Nobody cares. Lady Absa. Okay, I'll take that. I know some motherfuckers who'd line up to disagree with you, but I'm gonna take that. Thank you, beautiful. Wow. That's fast. That was fast. That was fast. Whew. These people. Wow. Well, guys, I gotta go. Get back to it. This has been very, very interesting. Very, very interesting. I guess we'll see what happens next. They got to set up a meet and confer and figure out if they can work it out. And if they can't work it out, we're either going to get them coming onto the docket jointly, or actually, yeah, we'll get a notice on the docket of a hearing that they've agreed to. Or I still think we're going to get another lawsuit. So go forth, be well, maintain yourself, your happiness, your joy, your peace. In the very least, your peace If you can't get to joy and happiness, that's fine. That's fine. Be content in silence, you know? I wish that for all of you because the world is right now, and we all need a little bit of peace and tranquility and isolation and contentment. Yeah, buddy. I will see you all soon. Be good or don't, really, at this point, you know? Yeah. Just be well. And I'll see you soon. Peace.